Hello, I'm Emily Lardner. I'm a member of the League of Women Voters. The League of Women Voters is a nonpartisan, nonprofit organization open to men and women. The purpose of the League is to help provide information so citizens can make informed choices when they vote. Voting, as you all know, is critical to having a democratic society. We thank Thurston County Television for its support for these educationals, and it's my pleasure to be here with two candidates for the Court of Appeals, Division 2, District 2, Position 2, Thomas Bjorgen and Pam Loginski. The way this forum works, each candidate has 2 minutes to explain, introduce themselves to you, the viewers. We have a set of 6 questions. The first person who addresses the question has 2 minutes. The second person has a respondent. We'll go back and forth, first, second, and then at the close, you each have a minute for your concluding statements. Ready?
Yes.
Okay. And Thomas, you'll begin.
Thank you very much, Emily. I'm Thomas Bjorgen, and am a candidate for Washington State Court of Appeals. What I would like to do in this opening segment is to give you an idea of my view of the work of the Court of Appeals. I think that more than any other branch of government, the Court of Appeals, when it does its job right, can almost serve as the conscience of the country or of the state. And that's because the Court of Appeals has in its care, in its stewardship, those foundational rights that make this country truly something to be proud of. Rights like the freedom of speech, the freedom of religion, the idea that everyone is of equal stature under the law, the idea that everyone is entitled to fair process under the law. Now, does the system always work well? No, it has its failings, it stumbles sometimes, but I think that it's important for all of us, judges, attorneys, and everyone else who's affected by this system, to keep in mind that this is the purpose of the system, this notion of a just and a principled and a humane application of the law to the facts of our lives. So we need judges with the courage to make their minds up on the basis of legal principle, not politics, not special interests. And we need judges with the courage to make the hard decisions that are sometimes needed to vindicate these rights that I just mentioned. But above all, we need judges also who observe proper judicial restraint. And by that I mean it is not the work of a judge to strike down laws or to change laws simply because he or she may disagree with them. That's the work of the legislative branch. It is not the work of the courts. Above all, though, we need judges who will always remember that that elusive notion of justice underlies everything that we do here, and that justice is not justice if it depends on who you are or whom you know or the size of your bank account or the weight of your influence. As your judge on the Court of Appeals, those are the principles I would do my best to follow. Thank you.
Pam.
I'm Pam Loginski. Thank you for the opportunity to speak with you. We also need judges on the Court of Appeals who have the qualifications and experience to do the job accurately and in a timely manner. I can hit the Court of Appeals running because I'm extremely qualified for the position, and here's why. First, I know the workings of the Court of Appeals. I clerked at the Court of Appeals for Judge Robert Windsor. Second, I've argued in excess of 300 cases in front of the Washington Supreme Court and the Washington Court of Appeals. I've written hundreds of briefs that have been successful in both courts. Third, I've dealt with laws from soup to nuts. I've authored bills, I've shepherded bills through the legislature, I've implemented laws, and I've defended statutes in the appellate courts. I serve on the Washington Supreme Court Committee that's responsible for updating and writing the pattern jury instructions. Fourth, for the past 12 years, in my role as staff attorney to the Washington Association of Prosecuting Attorneys, I've advised prosecutors in such diverse subjects as police procedures, Native American law, Public Records Act, and constitutional law. I look forward to answering your questions about my qualifications and background. Thank you in advance for your time and your attention, Emily.
Thank you both. Pam, I'm going to ask you the first question. You'll have 2 minutes, and then Thomas, you'll have a minute to respond. And the first question will repeat a little bit what you both shared with us, but it is, what experience do you bring to the Court of Appeals?
I bring the experience that I just described. I have had an active appellate practice from early on in my career as a new lawyer through now. I will be arguing 2 cases in the Washington Supreme Court between now and Election Day. In the last decade, I have represented, been a party or a friend of the court in over 46 cases in the Washington Supreme Court and the Washington Court of Appeals. I also bring a unique background in that I have trained police officers on search law, which means I have to take complex Court of Appeals decisions, translate them into rules that can be applied at the roadside in mere seconds. And in this training, I go to every corner of the state. So I know that what works in Aberdeen may not work the same way in Seattle. And I will bring that greater knowledge of the diverse communities that Division II serves to every decision that I make.
Thomas.
Thank you. In a nutshell, I bring a breadth of experience to this position and a demonstrated record of impartiality as a hearing examiner, a quasi-judicial hearing decision maker. I've been an attorney here in Olympia, Thurston County for over 30 years. I began as an assistant attorney general for the state of Washington, went on to become a senior deputy prosecuting attorney for Thurston County, and for the last 13 or so years, I have been a partner in a private law firm here in Olympia. My appellate work has been extensive, and it has reached into the United States Supreme Court. I wrote briefs on behalf of the state of Washington in 3 cases in the U.S. Supreme Court. I have argued cases in the Federal Ninth Circuit Court of Appeals, Federal District Court, the State Supreme Court, and the State Court of Appeals. And as I mentioned at the outset, I've also been a hearing examiner, which is a sort of administrative law judge for the city of Olympia, for Thurston County, and for other jurisdictions. In that role, I have been asked to make decisions the same way that a judge would make those decisions. And that has generated a written record of what I think is demonstrated impartiality in listening to the cases and making the decision that is most consonant with governing law.
Thomas, this is for you first. Maintaining a fair and impartial judiciary is a keystone in a democracy. Do you think maintaining judicial independence despite pressure from parties, political leaders, and private citizens is a problem? Why or why not?
I don't know if it's exactly a problem, but it's an essential characteristic in our judges, this notion of independence. And in fact, when I look back on, especially the U.S. Supreme Court, but the state Supreme Court too, some of the justices that I admire the most are those who have, in a way, transcended their backgrounds, who have confounded the people who may have appointed them by becoming judges, by acting as judges, by acting impartially, by not carrying a brief for one political view or the other. And that, I think, is just truly the essence of good judging. And I think you will see that in, as I mentioned before, the record of hearing examiner cases that I've generated over the last 12 or so years. And let me give just one example that many people here in Olympia will know about. Last year, as hearing examiner, I had before me a proposal to put a 7-Eleven in a small commercial building in West Olympia, the corner of Harrison and Division, thank you. And this was a very controversial case. And as a personal matter, I felt that probably the last thing that Harrison Avenue needed in that location was another fast food outlet and another commercial building. But when I looked at the law and when I listened to the evidence, it seemed clear to me that that proposal met the governing law. And so I issued a decision approving it subject to conditions. Now that decision was reversed by Superior Court. I'm not sure if there's been an appeal of that. If there were an appeal, then that in turn could have been reversed. We just don't know where it would have wound up. But the point I'm trying to make doesn't have to do with the result of the decision, but it has to do with the independence that I tried to show. Independence both from whatever preconceptions I might have and independence from the press of public opinion.
Thank you. Pam.
Yes, the Court of Appeals must be fair, but more importantly, it has to also appear fair to the public. And with regard to candidates for the Court of Appeals, it's really important to make sure that individuals are endorsed by people of both parties and people who practice on both sides of the aisles. If you have a candidate who only has Democratic endorsements or only has Republican endorsements, I think there is a perception among the public that maybe they're going to skew one way or the other. I am endorsed by Democrats and Republicans, by prosecutors and criminal defense lawyers, by plaintiffs' bar, and by Liability Reform Coalition. And I think this is in recognition of the work I have done my whole career as a quasi-judicial officer or prosecutor, and serving on Washington Supreme Court committees where the courts appointed me as a member to help in jury instructions to declare what's accurate, what is the law, not what prosecutors want, not what criminal defense lawyers want.
Thank you. Pam, we'll start with you for this question. How do you define judicial activism, and does judicial activism in the courts concern you?
I believe judicial activism occurs when the court steps out of its role of being, in Chief Justice Roberts' words, an umpire or referee, and into the role of legislative decision-making. A judge's role is to determine whether a statute matches or is consistent with the Washington State Constitution, the federal Constitution. It's not a judge's role to say, is this the best way of reaching this policy? Is this policy the one that I would personally pursue? Early in my career, I had a very difficult case as a law clerk where my personal inclinations would have led me one way, and the Constitution demanded a different response. And I went with the Constitution because I was terrified that if judges and others kept substituting their personal beliefs, no matter how benevolent, no matter how wise, we would descend into anarchy.
Thomas?
What a good question that is. Judicial activism is a phrase that gets thrown around a lot in public discourse, but it's one that is worthy of a lot of thought. On one hand, something that does count as judicial activism is necessary from our courts. I think especially of the case of Brown versus the Board of Education, the 1954 case where the U.S. Supreme Court said that racial segregation in our public schools was unconstitutional. Well, on one level, that was a very activist decision because it effectively put the Supreme Court in a way in the position of every local school board. But it was the proper decision. It had to be made to vindicate the principle of equal protection of the law. That, if it is activist, is proper activism. But on the other hand, we also see decisions sometimes where judges will strike down a law or where they will modify a law, and it is clear from their reasoning or from the argument that those decisions are made more on the basis of policy because the judges may disagree with the law than they rest on any legal doctrine. That is improper judicial activism. That is what we all must stay away from who are on the bench or who may be elected to the bench. The job of the judge is not to insert his or her own personal views on matters of policy into the law. The job of the judge is to make a principled and good faith effort to apply the law that is before him or her.
Thank you. Thomas, what would you say are the two most important criteria a voter needs to know about a candidate in order to make the right choice for a Court of Appeals judge?
One of the criteria is that of impartiality. I've already spoken about that somewhat, and I think you can see the type of impartiality that I would bring by the record of hearing examiner decisions that I already mentioned. And that notion of impartiality is also served by voters can also discern it, not so much from what we say, but from what we do. You don't have to believe what I am telling you. You can look at what I've done in terms of impartial decision-making. You can also look at my endorsements, and as is the case with Ms. Loginski, you will see Democrats and Republicans, you will see individuals from this interest group and that interest group. That doesn't necessarily guarantee impartiality, having endorsements from across the spectrum, but it certainly shows that neither of us actually are viewed as carrying water, carrying a brief for one position or the other.
I think it is difficult for voters to decide who to vote for in judges. And there's a wonderful service called votingforjudges.org that collects the information about every candidate. And one of the bits of information that Voting for Judges collects is the evaluations of different bar associations. And these bar associations do the work that voters wish they could do. They review a candidate's entire body of work. They speak to opposing counsel. They speak to colleagues. They speak to the judges we appear in front of. They look at our community service. And votingforjudges.org puts all those ratings on a grid, and I have been consistently rated higher than Mr. Bjorgen. I've been rated exceptionally well qualified by Washington lawyers, 3 other bar associations, well qualified by another 3 or 4 bar associations. That's one place that voters can go. Voters should also look at the current practice that we maintain. In the last 10 years, I've been in the appellate courts 46 times. Mr. Bjorgen hasn't been there. Voters should talk to other lawyers, colleagues, to obtain information.
Pam, back to you. How will your background affect the balance of experience and perspectives on the Court of Appeals?
The Court of Appeals Division II is an incredibly hardworking court, and most of the judges are from larger urban areas. My background is incredibly relevant. Over half of the cases that come before the court are criminal matters. And criminal law has undergone profound changes in the last 6 years with the U.S. Supreme Court enacting decisions that changed all the notions that we had of search law, sentencing law, confrontation clause. My background will assist the court in that I have been in a position to bridge the gap between appellate court decisions and the police officers who have to implement those decisions. Also, as I spoke before, I have the experience of being in many different communities, many different sizes of communities. And so that's some of the balance that I can bring to the court, along with the fact that having served on the Pattern Jury Instruction Committee, where we have to take the statutes and the court decisions and implement them in the courtroom, and in my current role, taking statutes and developing the court forms and developing the procedures for implementing them, mean that every decision that I render will be with an eye to providing enough guidance in that decision so that courts and attorneys and just everyday citizens know what they're supposed to do to be in compliance with the law.
Thomas.
I've mentioned already this notion of impartiality, just how important that is to judging. And I have no doubt but that both Ms. Loginski and I would do our level best to be impartial at that court. Nobody's a blank slate, though. Everybody brings to their work, whatever that work may be, their background, their experience, and that can have an effect, even if it's an unintended effect. At this point, not counting Judge Armstrong, who is retiring, there are 4 judges on Division II of the Court of Appeals. 4 out of 7 have strong criminal prosecutorial backgrounds. If Ms. Loginski is elected, that would result in 5 out of 7 judges having that singular background on the Court of Appeals. I think one of the greatest safeguards we have in the court system against implicit bias from one's background is to have a diversity of backgrounds on the appellate court. With 5 out of 7 having the same prosecutorial background, that balance, that diversity would be jeopardized in spite of the subjective good faith that all judges bring to it. And I think this is reflected in the endorsement which I have received from David Armstrong. Judge Armstrong is the incumbent in this position that we're running for. He is retiring, and Judge Armstrong has endorsed me to succeed him, stating that he believes I am the most qualified candidate for this position. I believe the package, if you will, of experience and background that I bring to this court would bring to this court, that would most appropriately, most precisely fit the background and experience that Judge Armstrong will be taking with him when he retires.
And Thomas, this is our last question. There are concerns that increased campaign expenditures in judicial races will eventually compromise the integrity of our judges. Do you agree that this is or could be a problem in the state?
It certainly could be a problem in the state. And the question, I assume, is based on the recent United States Supreme Court decision in Citizens United, which basically has opened a flood of money, not just, well, actually not so much into judicial races, especially into the partisan races, but it is a flood of money that can affect judicial races too. I think that Citizens United case was poorly decided. I think it rested on a sort of a simplistic analysis that spending money on advertising is a type of speech, therefore it cannot be restricted. What that decision ignores, though, is the fact that when one speaker has a megaphone and when one speaker is whispering, the marketplace of ideas just does not work. One side can drown out the other side. I don't believe that has so far become a problem in judicial races. I have not seen evidence of that here, certainly not in the Court of Appeals races, and not so much in the state Supreme Court races either. But there certainly is a threat of that. I think it would be a tragedy if well-moneyed interest groups, no matter what side they were on, this isn't a partisan point in any respect, but it would be a tragedy to the judicial system if big moneyed interests began to throw that weight around in judicial races. We have to live with Citizens United, but we must discipline ourselves, the bar and the bench, as much as they can, as much as we can do, consistently with that case to prevent that from happening.
Pam?
I think in Washington, first, people should know that there is a pretty strict limit on how much money can be donated directly to a candidate in a judicial race. And it's $1,800 per campaign from individuals or organizations. And so that means there's unlikely that any one person could be considered as buying or influencing an election. There is a proposal, I believe it's now been adopted, for amending the rules that judges are governed by, the Code of Judicial Conduct, that requires a judge to step back if one of their major donors has been a contributor to their campaign, is now standing in front of them. Also, judicial races, particularly the Court of Appeals, which is an error-correcting court, and most people don't know where we are, sandwiched between the local Superior Court and the state Supreme Court. It's not really been a big money issue. I think the bigger concern and the bigger problem in Washington judicial races is just getting information out to the voters, which is why you're providing such a beneficial service with this forum.
Each of you has a minute for a closing statement, and Pam, will start with you.
Thank you. Thank you. I am Pam Leginsky. I am a candidate for the Court of Appeals, Division 2, District 2, Position 2. I'm endorsed by Democrats and Republicans, prosecutors and criminal defense lawyers, Plaintiffs' Bar, and Liability Reform Coalition. I'm endorsed by Judge Robin Hunt, who currently serves this district on the Court of Appeals, by current Thurston County Prosecuting Attorney John Thunheim, by past Prosecuting Attorney Ed Himes, by Sheriff Snaza, and by Brandon Williams. I am endorsed by citizens throughout the district. I am someone who has served my community my entire life, from as a Navy hospital corpsman to deputy prosecuting attorney, to a volunteer in my local community of Port Orchard and Bremerton at Benedict House, which is our shelter for homeless men, our animal shelter, and in my faith community. I'm Pam Luginski. I would like your vote and your support so I may serve you in this new role. Thank you.
Thank you. And Thomas.
We have in this country a magnificent principle that applies to us all, and that is the notion that we are all subject to the rule of law. We're not subject to the whim of kings or the caprice of tyrants, but we're subject to the law. And it's not just any body of law, but it's a law that is founded on the notion of fairness, founded on the notion of equality under the law, equality of stature. And as I said at the outset, the system does not always work well, but it is a magnificent goal for us to strive for. And if I have the privilege of serving in this position, the basic goal that I am going to be working toward is to ensure that those principles are not just ink on paper, but that they are implemented in the real world. Just in the last couple seconds here, a little bit more about endorsements. And judicial ratings. I have been rated exceptionally well qualified by Washington women lawyers, well qualified or qualified by other rating organizations. Just last week, the Kitsap County Bar Association, in their preference poll for this race, chose me as the #1 candidate. I was very gratified about that because I am not a resident of Kitsap County. In the last couple of weeks, I have received the endorsements of 2 former Chief Justices of the state Supreme Court, Justice Gary Alexander and Justice Robert Utter. In addition to that, if you go onto the website, bjorgenforjudge.com, you will see numerous other endorsements, both from organizations and from individuals. As I said before, you will see Republicans and Democrats, you will see Court of Appeals judges, you will see a sitting state Supreme Court judge, in addition to the retired Chief Justices I just mentioned, and you will see many office holders. I would ask your vote in this position. As I said before, my single goal would be to ensure that these principles that I have mentioned several times now, the notion of fairness, impartiality, and equality of status, are fully implemented. Thank you very much.
Thank you both very much for being part of this forum. We are fortunate that we have 2 thoughtful, qualified candidates willing to be candidates, willing to stand for this position, and so it's the responsibility of all of the rest of us to actually learn more and then vote. Thank you very much.